Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about when probate is necessary in Illinois. When a loved one passes away, if you're the executor or trustee responsible for administering their estate, you first have to get a document that gives you the authority to distribute their accounts and their real estate first to creditors that are owed money to by the deceased, or if there are no creditors, to the heirs of the estate. So that those documents can either be a small estate affidavit or they can be letters of office that are issued by a probate court. Letters of office are basically an order from a court giving you authority to distribute accounts as the executor. So probate's about a year-long court case, and in a probate case you've got to give notice to creditors and heirs and wait for a 6-month notice period to pass where creditors can file claims. And then after that notice period, as the executor, you have to file a report with the court and get an accounting approved by all the creditors. So it's ideal to avoid it, and with good estate planning, you can do that. So we're going to talk about today when probate is actually necessary and what you can do to avoid it. So probate is necessary in Illinois when one of two things is true. Either you own any real estate outside of a trust that's not held in joint right of survivorship, and we'll circle back and talk about that in just a minute, or if you own more than $100,000 of non-real estate assets outside of a trust that doesn't have a direct beneficiary named on the account or isn't payable on death. So let's talk about real estate first. For real estate, most married couples own their home with joint rights of survivorship, meaning that when one passes away, the home passes automatically to the survivor. If this is the case, then even if it's not in a trust, probate won't be necessary. If the second spouse passes away, then if the real estate isn't in a trust, then a probate case is required, even if the home is underwater or there's very little equity in it. So that's why a lot of people have trusts as part of their estate plan, is to transfer their real estate, the ownership of the real estate, into the trust so that it's out of their estate for the purposes of probate. So again, when you pass away with any real estate, it can be a condo, it can be a timeshare, that doesn't pass automatically to someone else, either through a trust or through rights of joint survivorship, then in order for someone to get authority to deal with any of your accounts and pass any of those accounts to your heirs, then they would need to go through a probate case, and they can't do it by a small estate affidavit. The second piece of the puzzle is if you own more than $100,000 of non-real estate assets that aren't on payable on death accounts or don't have direct beneficiaries named. So if that's true, then even if you don't own any real estate, probate is going to be necessary to distribute your estate. So let's pick that one apart a little bit. Payable on death accounts are accounts that the bank actually has on title that when you pass away, they're payable directly to some other beneficiary. When that happens, it doesn't go into your estate. It goes directly to that person. And often on IRAs and life insurance policies, there will be a direct beneficiary named that it will go directly to rather than getting dumped into your estate. If you don't have one of those two things happening on your account, then the way you keep those accounts out of your estate and out of probate is to also, like the real estate, transfer them into a trust. And if they're in a trust, they're not part of your estate. They get passed according to the terms of the trust, not through a probate case. So to circle back a little bit, the rule in Illinois is if you own any real estate outside of a trust or own more than $100,000 outside of the trust, then in order for your executor to distribute your estate to your heirs, they have to go to the probate court, get letters of office issued, and then the court is going to oversee the distribution. And that costs a lot of money in attorney's fees, and depending on who you go to, we try to be affordable. But it's a little bit of a headache for the executor, and it takes about a year. So the alternative is if you've done your estate plan appropriately and transferred most of your accounts and your real estate into a trust, then rather than going through a probate case, all your executor has to do is download a one-page form off of the probate court's website called the small estate affidavit. And in that affidavit, they testify that there's a trust in place, and they're the trustee of the trust, and there's no real estate outside of the trust, less than $100,000 outside of the trust, and therefore probate isn't necessary. And in the affidavit, they'll lay out which creditors are going to be paid from the balance of the estate and how much each heir is going to get. And they take that affidavit to a bank or to an attorney's office, get it notarized. They don't have to file it anywhere. But with a copy of that notarized affidavit, a copy of your death certificate, and a copy of your trust, they can then go about and liquidate the estate without having an attorney involved, without going through the probate process, and everything passes immediately. So when people come to me to talk about estate planning, usually what we're trying to do is make sure that their estate is set up so that everything that needs to be in a trust is in a trust, so that probate isn't necessary, and it saves their trustees and executors a lot of time and money. So if you have any questions, you can call me and schedule an initial consultation. My phone number is 630-324-6666. And you can find more videos and articles and podcasts about legal topics at learn-about-law.com. Thanks for your time.